of our technical issues. I just wanted to introduce myself, although you saw me on C-SPAN, which for me was a very rewarding experience, but as I said to Renee, somebody who doesn't do social media at all, and then I'm thrown into the national spotlight, so it was a lot, and it's hard to look at yourself, but I was very honored and privileged to have that opportunity, and I was there with Renee in DC and so many others that have done this work in Washington State in this past year. And I want to briefly introduce my colleague. This is Sergeant Eric Pisconski, and he is, I would say, the state's expert for law enforcement on extreme risk protection orders. Just to give you some context while they set us up, in King County in 2018, our unit assisted on 71 extreme risk protection orders in some capacity. So that's not a ton, right? But compared to, I think, 2017, where maybe there were just a handful, like 5, under 10 for sure. So the big change in work in our office came after the Parkland, Florida shooting. And that's where we really saw a change from law enforcement and the public getting more inquiries about what is an extreme risk protection order. And I just want to ask, has anybody worked on one? I know Sergeant Ferguson, I believe his folks have done several. Any other law enforcement you have? Okay. And what capacity were you working on it as an attorney, a judge, officer?
The legal advisor for the sheriff's department.
Okay, great. And did it go smoothly?
The hearings?
Yes.
Yes. Pierce County has assigned the presiding judge to handle them, so it's very easy to get coordinated. And we have the same judge, you know, for the statute because they're the ones that are handling them.
So that's really helpful to have one dedicated judge that's hearing extreme risk protection orders, because we have the sort of unfortunate experience of each week we go to these hearings and we don't know until the morning of who is going to cover that calendar as far as a judge. And so we're really, part of our efforts in this past year is not only to help train law enforcement that this is a tool, to train the judges to understand the law and its applications because they're nervous, it's a new statute, and to also, most importantly, I think the area that I see is to also train the public. So our advocates and our therapists and our doctors and other folks, that this is really an option out there, an important tool. And just to give you a brief context, out of the 71 cases that we worked on, 69 of them were from law enforcement. So 69 were law enforcement petitioners from 14 different agencies in King County. So King County has 39 different law enforcement agencies. So 14 out of 39. No, I'm not sure. We probably have a lot more training that we need to do in our own county as well. And we had 2 family member cases. And Lorinda, who's right back there, you'll hear from her later, she helps with any family members or the public that kind of reach out and need some assistance on extreme risk protection orders. So that's just a tip to think about if you have an advocate. Maybe think about somebody getting some specific training in extreme risk protection orders. Okay. And just real briefly on the background on extreme risk protection orders, this passed by Citizens Initiative in 2016 by almost, I believe, 70% of the vote. So overwhelmingly supported. But as we've kind of known, it's just not widely adopted yet. And so that's why our hope today is to share that information. My portion is just to give you a brief overview of the law. I'll turn it over to Sergeant Pisconski, who will go through the case studies and give you more interesting details about what his unit does. So this was, Washington's law real briefly was modeled after the Isla Vista shooting in California. And unfortunately that occurred in, I believe, 2014, where I'm gonna call him a defendant down there, I think he was 19 or 20 years old. And the most significant thing to realize about that is that his parents at the time went to law enforcement. I think his therapist went to law enforcement, and they said, we have some concerns about our son's behavior. And law enforcement responded, but unfortunately their hands were tied because the defendant had not made any direct threats to kill and hadn't committed an actual crime. So his family reported to law enforcement, I believe on April 20th or something, or April 23rd of 2014, and then on May 23rd of 2014, he killed 6 people and wounded 14 others. He killed 6 college students, including one of them, Veronica Wise, who has a connection here to Washington State. And as a result of that horrific homicide, California passed their gun violence restraining order, and we modeled our extreme risk protection order in Washington State after California's version. So the basics on extreme risk protection order, what is it? This is a tool to allow law enforcement and families the ability to intervene in moments of a behavioral health crisis. And we'll talk about the language that just changed recently in the statute. But it's really a tool to come in before the gun violence occurs. So the legislative intent is to prevent future gun violence. And what it does is it allows this court order, it's a civil order, comes into play, and it's just about the firearms and the concealed pistol license. So unlike any other protective order in our state, the stalking orders, domestic violence protection orders, all of those have restraint provisions between parties. The extreme risk protection order, when you hear that, just think that is guns, firearms, and CPL only. Okay, so that's the official definition. Sorry, I'm a little out of order here. Okay. And so if somebody's subject to an extreme risk protection order, we're going to talk about it in a moment. It's a 2-part process, just like all of our civil protective orders. All the ones that we've assisted law enforcement on have been done on an emergency or ex parte basis. And I think that's what you're going to see. I mean, if you're getting an extreme risk protection order, we're not going to give the respondent notice to come to a hearing where the court may issue the extreme risk protection order. So these are all, in our experience, being done ex parte or on that emergency basis. And once that order is issued, either at the temporary or at the full hearing, which is the second part, it theoretically is supposed to get entered into the criminal data systems. We know it's hitting WASIC, so our statewide database. We do have some concerns about whether it's hitting NCIC, which would be your III, the National Criminal History. And the reason for that is we're working on that, so we're trying to get solutions. We've talked to our federal partners, and we're hopeful that that'll take place. But that's just something to know about from a law enforcement safety perspective, that somebody could be subject to an extreme risk protection order, and it may not show in NCIC III. So, yeah. That's it. So the criteria for evaluating an extreme risk protection order, we're going to talk about the factors that the court can consider, but the main things that an extreme risk protection order, the intent is to look at somebody's, we used to say behavioral health crisis, and Sergeant Pisconski describes it much better than I do. He says that's a focus on words, actions, and behaviors.
Words, actions, and behaviors.
Thank you. So I adopted that because that's the best way to explain it. And he'll give you some insight from his years of experience about how it's not just about somebody having a mental health issue, right? And that's an important thing to understand. So when we talk about extreme risk protection order, we're going to talk about threatening behavior, right? So talk about somebody who's really in crisis, or are they exhibiting violent behavior? So in Washington State, who can file? There are Washington's little unusual in the sense that we're limited to either law enforcement or family or household member. So you can see what family member is defined as, and household member is a roommate that's resided together in the past year. Is there a category of folks that anyone's surprised that they don't see up there? Sometimes people say, well, what about therapists and medical professionals? Teachers, school officials, we get that a lot. So I think Maryland has therapists and medical professionals.
Maryland has large, medical period, which includes behavioral health. Mm-hmm. And then what state just added teachers? I'm not sure.
Is it Florida?
I think it was Florida just added teachers. And when we were developing the law in Washington State, the medical community did not want to have anything to do with did not want to have anything to do with it at the time. They're now very interested in having the ability. So we're sort of seeing what unfolds in Maryland to see if we think that would be a good thing to add to our statute here.
And we also get coworkers, sometimes people ask about employers, that sort of thing. And I can tell you, we've had a couple cases where therapists have reached out. We've had doctors from the VA especially, and therapists. And so we kind of guide them in the sense of what the extreme risk protection order is, but at some point they have to make that decision if they have to breach HIPAA, if it's a duty to warn and that type of thing. And we've had a couple, we've assisted therapists, and then some others where I'm not sure what they did because they didn't disclose to us who their concerned patient was. And we respect that. We're just trying to give the information. So where can you file? So in Washington State, if you're filing an extreme risk protection order, you can file it by statute in any court. So that's our courts of limited jurisdiction, municipal district courts, or your superior courts for that emergency temporary order. We will tell you that the vast majority of district courts and municipal courts are not, I don't know if they've been trained to file it, so if you, maybe a good practice point to start that discussion, to call your clerk's office if you're law enforcement to figure out ahead of time. Because we've had, I know in Kirkland and some others, had a really emergent extreme risk protection order, and the clerk's office was very well intended, but could not figure out the process because it involved transferring it to superior court, and so that was a little bit of a struggle, and they ended up driving down to Seattle the last minute to get in front of a superior court judge. So figure out your process, but you can go to any court. And the law just recently changed, Senate Bill 5027, if my memory is correct, to allow, starting in July, law enforcement can petition after hours for an extreme risk protection order. And I'm sure they're mapping out that process, but I anticipate it will be done similar to a search warrant. I did one many months ago, and I treated it like a search warrant process and was able to get it issued after hours. It was kind of a nightmare to clean up with the clerk's office because we didn't have a process, but it can be done.
As part of that, they're officially putting law enforcement to the front of the line for petitioning. So if we go in person, that was one of the struggles that we had, quite frankly, is we would go into petition, and depending on the judge and the docket, we just, okay, yeah, you guys wait over there and we'll get to you when we have a chance. And again, by definition, extreme risk protection order, this is very, very timely. So part of House Bill, Senate Bill 5027, that was also changed. There's a bunch of legislative fixes that came through which are really important to us, and I'll touch on some of them. But that was one of them. Is now it's officially in the law that law enforcement goes to the front of the line when we're petitioning for those. So that's a big deal.
And you may have to remind, if you're law enforcement or you're going in, you may have to remind the clerks or the bailiffs that that is, because they probably don't know, just to say that we have an emergent law enforcement issue. That's what I've done before, and it tends to help.
Be nice.
Yes, tends to move it along. And so once, just to back up real quick, so once the temporary is issued by the court, it automatically will transfer to superior court. So the full hearing is always in superior court, and that's by statute. And that will occur within 14 days of the issuance of your temporary or emergency ex parte permit. Okay. And just like anything, and Eric can talk about this, but it does require law enforcement to serve. So once that emergency order is issued, law enforcement does have to serve, just like any other civil protection order, serve the respondent, and within 5 days of the next court hearing. So that's a two-part process we already talked about. So the forms that you're going to need for filing, this is a very basic layout. We have also links to our website, which has forms as well, and we're happy to guide, and I know Sergeant Pisconski would be happy to as well if somebody, law enforcement is unfamiliar or needs some assistance. But basically you need a petition, you need your LEIS, and the one tip that we always say is to bring multiple copies of your LEIS. You will need that for filing at every phase with the clerk's office. So don't just do one and then toss it, because they will require you to do it again. So just make a bunch of copies. You'll need your return of service and then your temporary extreme risk protection order. And a practice tip is to make sure to fill that out for the judge ahead of time. We are going to go ahead and check the findings that I want the court to make. And that's because we've accidentally gone in and realized that the court signed it but did not make any findings. On the first one we did, we just were unfamiliar with what we were doing. And so we quickly learned, we've gone ahead and pre-checked the findings, and then if the court wants to cross one out, that's fine. But we're kind of trying to guide the court on what we think is appropriate.
And for law enforcement, just like we do with any search warrant or other orders that we go and get, make sure they actually signed it make sure they actually did it. We've had that happen where we've gone in and gotten it, it's been granted, we go out to serve it, and realize upon service that the judge didn't actually sign it, or they didn't date it. So now we got to go back to the court, have them do it again, then come back and serve it again for it to be official. So it's little stuff, it's minutia, but make sure all that's done correctly at the time.
I don't know if that'll work. We can try going get it quite long. This was just a copy, but nope, it's not going to do it for you. Okay, go back. Go to the next one. Okay. So when a court is looking at an extremist protection order, both at the temporary and the full hearing, there's now 16 factors that the court can consider when issuing that. And at the emergency phase, it's reasonable cause, which is similar to probable cause. Okay, so it's not a really high standard at that emergency order. Come to the full hearing, it's by preponderance of the evidence, just like all of our other civil protection orders. Okay? And so the court considers, I think the big one is threats of violence against self or others. And I would say that almost everyone that I can think of has had that factor. And also the court considers, just like you heard David and Chris talk about, domestic violence. So they're going to consider arrests, convictions, they're going to consider any violent history, stalking behaviors, any protective order history, that's really important. And also, one that I didn't make the connection to as much until more recently was the abuse of controlled substance or alcohol. And I think that's in a lot of the ones I've seen. I would say at least 60 or 70% of the protection, or the ERPOs that we've worked on have had a substance abuse issue as a factor.
Especially the danger to self ones, the suicidal folks, because that tends to be a pattern. Individuals will engage in substance abuse, alcohol abuse, and then get into that suicidality, that pattern. Now they're introducing a firearm into the equation, and okay, we see this. So that's our concern, right? They have this pattern that they're engaging in with their behavior, and then they're also introducing firearms to that equation. And so we want to try and interdict in that.
So we just wanted to highlight some of the new changes. Both Sergeant Pisconski and I testified in support of Senate House Bill 5027. Some of the, and Renee would know it best if we were off task.
Tallman.
Tallman. The really significant things, I would say some of the language changed a little bit. So instead of saying, I think it was dangerous mental health.
Dangerous and mentally
Ill, yes. So the language has changed. So now the court is to consider threatening behaviors. And we believe that that also can encompass some of the ideology or the hate crimes. And so we have seen a couple recent cases in the last couple months, and then one just 3 weeks ago, a really concerning case that clearly was ideology, some concerning ideology was in there as well. And then the court can also consider a malicious harassment conviction. So that's our hate crime statute in Washington State. It also clarified its application to minors, and this came up in the mass shooting work group, results in the mass shooting work group, which was a bipartisan work group across the state, and they studied school threats and school analysis of mass shootings involving schools, and determined that there were some gaps in that, because before the extremist protection order was silent as to minors. We know that minors cannot possess firearms, or purchase firearms, I should say. So the issue really became access. And we had that come up in a couple cases in King County where a minor was charged at juvie with a crime involving school threats to kill other students. We knew that the parents in that home had firearms. In one particular case, the parent, the dad, was not cooperative with law enforcement about giving us reassurances about what he did with those firearms. And so it became this issue of whether the court had jurisdiction, not over dad, who hasn't done anything wrong, but over the issue of can that child remain in the home with access. So that's just an issue to be aware of. And the statute also does contemplate that if somebody was to file a false ERPO petition, that it would be a crime. We haven't seen it. Some of these are, the court process is not particularly convenient always. I've never seen one that I suspected was a false one. But if you do that, it's a gross misdemeanor. And we have had folks that have violated the extreme risk protection order by having firearms. Most of those have been after we have issued a search warrant, or SPD has issued a search warrant. and recovered firearms. And so there's a handful that have been charged with that. And most concerning too, I think, is the folks that have gone out and tried to purchase firearms. There's been a couple.
Yeah, we had a couple early on where we pursued, everything was done and settled, and then these individuals went outside of King County to try and go purchase firearms. And so there's kind of that question of, did they think this only applied in King County? Because one of them drove all the way to Ellensburg and the other one drove up to Linwood. And so they made an effort to get outside of the county to try and go purchase those. But as the system worked out was supposed to, it immediately flagged when those firearm dealers went and did their records check and went, wait a minute. And they, as required by law, immediately contacted local law enforcement, the prosecutors, and then they coordinated with Kim and her folks to try and say, okay, how are we moving forward with this? Ultimately, the offense lies with the jurisdiction of occurrence. So Kim, as happy as she was to assist in prosecuting those or filing those, it ultimately falls to those jurisdictions to go and pursue that. So.
And I'm not going to go into all detail of these, but hopefully you have the materials, but to just show a pattern of different types of cases that extreme risk protection orders can apply to. So we've had, which I think is sort of interesting, we've had the State Patrol DUI arrest where an individual was making statements about wanting to commit a school shooting. We've had folks that have been a danger to themselves or others, as well as one that Sergeant Pisconski's team recently worked on, the top one there, with a respondent taken to a local hospital by his girlfriend and expressing fantasies to his girlfriend about wanting to commit mass shootings. And then there's some really concerning ideology as well. And I'm going to turn it over to Sergeant Pisconski, who's going to talk to you about SPD's process and give you some great case examples.
Answer a couple questions.
Yeah, sure. Does anybody have any questions before we transition? Yes.
Yes, I was just wondering if law enforcement or your unit and your court manager, whatever, if you're getting notices from the county designated mental health professionals when they get called to a crisis scene, but they aren't appropriate to go through the involuntary mental health commitment procedure, but they are exhibiting all these signs that are now in the ERPO law. Are you getting those?
We are not getting those. And we've gone up and trained at ITA, our advocate that's up in Harborview for us, but we generally do not get a lot of communication at all. So that may be an area, and I don't know if they will communicate with us, they'll share that information.
I apologize, I was pulling this up, I didn't hear the original question.
I was just wondering whether law enforcement or the unit itself was getting referrals from the county designated mental health professionals that are called into crisis scenes that may be individuals appropriate for involuntary mental health treatment, but actually they aren't quite gravely disabled enough to be going that route.
Sure. Yet
the mental health professional is observing things that kind of fall within the whole ERPO scheme, and they're aware of firearms. Do you get any through that system?
Yeah, absolutely, and it's relationship building, right? We've built a pretty solid relationship with the King County DCRs to be able to do that. We communicate very frequently back and forth. We assist them when they're serving their orders and vice versa. So it becomes a relationship issue to get those referrals. And again, going back to the medical professionals and therapists, and while they can't officially petition for an ERPO in the state of Washington, most of those come through law enforcement, whether it's under Volt for duty to warn or whether it's just, hey, here's a concern in general, and they're going to reach out, call 911, and then start that process. So we've had a handful of them that have either come from DCRs, mental health professionals in general, case managers that are service providers, and hey, I've got a client, I've got a little bit of concern here. And so it usually generates as a police response, maybe not a 911 call, but at least a referral to us, and then we would go out and investigate that. So that's the big crux of, and I'll talk about here in a little bit, the unit that I run, and that's how we started, right? So again, I'm Eric Pisconski, Sergeant of the Seattle Police Department, and I run our crisis response unit. So we are responsible for all things mental health related in the city of Seattle. We have a little bit of work. So that parlayed very well into the extreme risk protection orders, right? Because the bulk that we've seen have some nexus to, well, it's not required, there is some nexus to a mental health and or substance abuse issue, and then there's that behavior that's concerning, right, with that nexus to firearms. So we'll use here. Can you guys all hear me without the microphone? Okay. I yell a lot. So this is, again, some of this is a recap. This is how the law originally read, right? Demonstrated evidence a person poses significant danger. It did read dangerous mental health crisis or violent behavior, and with the change in 5027, it moved over and said that, came in front. Threatening or violent behavior, right? And you know, that's good, because there was a little bit of a misconception when this first started that, oh, well, this person has to have a mental health issue, right? And you start balancing that line of, are we criminalizing mental health to, you know, okay, anyone that's got a mental health issue, we're gonna go get their guns from them. And that really wasn't the spirit of what this was designed for. And so cleaning up some of that language, I think, is a little more appropriate. As Kim mentioned, we focus on the words, actions, and behaviors of an individual, whether it's with an ERPO or whether it's with just an emergent detention or some sort of a crisis outreach or intervention. So that's where our focus is. Let's give some of the theatrics with this. So again, this change there of any dangerous mental health issues changed to behaviors that present an imminent threat of harm to self or others. Right? That's really more in line of what we're focused on and what this is applicable to. So we early on decided, okay, this is going to be a pretty big deal. You're going to have some different sides of the argument, folks that are going to be for, against. How can we try and ensure the validity of this process and make sure that we're focusing on the right individuals and the right circumstances for the right reasons? So we developed our own internal vetting process so that we can say, hey, this is what we do, this is how we do it, and this is how we can defend it, and how we can make those decisions. So to that end, we go through, and any of the stuff that might come to our purview. As a unit, as a department, we're closing in on about 12,000 crisis calls a year as the Seattle Police Department. Every single one of those calls has a report written. Every single one of those reports comes through our unit. And we are vetting that stuff either live in the field as we're assisting patrol, or on the back end as the reports are coming through. And what we're looking for is individuals and instances that might be applicable for the pursuit of an ERPO, right? So if we see something that, you know, initially raises a flag somewhere, we're going to go through this vetting process. And we're going to be pretty extensive in how we get from point A to point B if we're going to pursue that. So, and I can make all this stuff available after the fact, so I promise I won't read slides. No one wants to do that. That's my PowerPoint. So just as an example, so I just captured our 2018 stats and up through 2018 to bring to you guys. Obviously, we've done more this year, this 2019. But since the beginning, when 1491 went into play, we're concerned with due process. So we went petition. We felt we had enough. We had reasonable cause to believe that this person met that criteria. We petitioned for an ex parte order. It was granted. It was served. They came back 2 weeks later for their hearing, and they presented their side to the judge, to the court, and the judge said, I'm going to not grant this full order. Okay. Now, we fully disagreed on all three of those. But that's the court system at work, right? The judge evaluated the information, they listened to what the respondent had to say, and they said, I'm not going to grant this order. Okay, yeah.
Eric, in those situations, was it that they disagreed with your assessment, or was it that the individual had sought help in the time period?
They had not sought help in any of those.
Okay.
So we had it. So again, Kim talked about early on, there's an education piece that's missing, okay? And unfortunately, this is what happens when we pass legislation and don't fund it. But that happens. So there's a piece missing, and some of these were early on that we had with judges where we went in, and I'll give you an example. One particular judge said, I am not going to grant this order because this individual was not emergently detained at the time of initial incident. So therefore, it must not have been that big of a deal. There is no requirement in the law that says there even has to be a mental health component. Period. It's not a requirement. So to have a judge say, well, the DCRs didn't detain this person in this initial 5-hour barricaded, suicidal, armed with a handgun, individual SWAT call out, taken to the hospital. The DCRs chose not to detain that person, which is on them. But to use that as the reason why I'm not going to grant this order. So we disagreed, agree to disagree. But the judge made that decision. So that's the process. Yeah, none of them had pursued treatment in that 14 days in between the stuff there. But hopefully we've gotten some of that stuff ironed out a little bit better. We're working on some better education pieces. To balance that out, we have evaluated, we've vetted an additional 53, okay, of folks that we've chosen not to pursue. So in 2018, that was 50 of them. Again, it's very heavily weighed to the male versus female. There was a total of 48 guns owned in these folks here. So again, just because there might be some indication and they own a firearm, we're not automatically going and pursuing these ERPOs. In our world, it has to meet that criteria, right? We do not want to turn this into a gun grab. We're trying to balance that constitutionality and that behavior. Are they a threat to themselves, to others, to society at large, and what is that intersection there? So, biggest reason why we're not pursuing them, they're already ineligible. Okay, again, this is a civil order. If they're already ineligible to possess firearms, what is the civil order to say you can't possess firearms? It's already a felony if you possess firearms. Yeah.
Sorry.
No.
Is there, in those situations, is there any attempt to remove potential firearms, or are you just done with it?
No. Yeah, and I don't mean to say that we walk away as law enforcement. If they actually had a firearm, then that's a whole other thing. That's felony charge over here, and that's being pursued. We're just not pursuing an ERPO for it,
Got it.
right? Because that would be kind of redundant. Yeah, here's a misdemeanor charge for the felony offense that you already have. So, yeah, but a lot of those, they didn't actually happen, right? So here's someone who maybe made all the indications. Okay, so you have that words, actions, and behaviors over here, and they're indicating their intent to obtain a firearm and commit certain acts. So everything added up, so we go, okay, well, let's vet this out. Let's see if we can pursue this. And then we go, oh, well, they're already ineligible to possess. So while they might be saying all the right things, legally they can't obtain a firearm. So again, if we pursue an ERPO, okay, that's a misdemeanor if they violate that civil court order and they obtain a firearm, but if they go and obtain a firearm illegally and they're caught with it, well, that's a felony. And there's kind of that balance there. Okay, just a general snapshot of some age categories of petitioned and not pursued. So it's pretty even. Most of our folks in their 30s are 20s and 30s are our highest utilizers there. We did choose to not pursue an ERPO on a 92-year-old individual for various reasons. All right, a couple of case studies. So this was one early on that we came across here. So this was right on the heels of the church shooting down in Texas. And we had an individual that was making similar threats. Okay, he had attended 2 different churches, one inside Seattle, one outside Seattle, both in King County. Had been active in their social groups for quite a while, and something changed, and he started to make some postings, started to make some threats, gonna burn the church down, gonna shoot everybody up. It came to our attention. So we started pursuing that, and ultimately we were able to recover a handgun and an AR-15 that he had. He was arrested and booked and charged with those crimes. These are some of the messages that he was sending. He did not put in the characters, I put those in. But yeah, so these are pretty specific stuff that he's out there saying, right? These are things that he's posting and sending to them. This was the last post that he had right before we contacted him. And he posted this on social media, going on an adventure. So we thought we had a pretty solid case. We did. that was one of those things where too, it was a multi-jurisdiction incident, right? Because we had Seattle, Bellevue was the location of the other church, the guy lived in South King County, and we were able to locate and arrest him in Issaquah, right? So this was a very large regional coordination to be able to get this guy. This was another one here. Again, you see the casino picture there. So right on the heels of Las Vegas, the shooting down there, we had this incident come up, and this guy, well, the other guy had kind of a history of odd behavior and low-level crimes. This guy came out of the blue, right? This was no previous criminal history, no previous mental health documented issues or anything like that. 67-year-old retired engineer, married, family, the whole deal. As you can see in this, he started this very abnormal pattern of behavior, started becoming very paranoid, ended up kicking everybody out, everybody over for dinner, extended family over for dinner, kicks everybody out, making a bunch of paranoid comments, and they leave. Some of the family is still in the neighborhood. They hear what they think might be gunshots going off inside, call 911, massive police response that shows up. They see him actually walking around in the house. No one can confirm that he actually fired a gun, but he's the only one in the house, and when law enforcement showed up, he's just walking around inside the house carrying his rifle. That's it. He's alone in his house, no verification, hadn't made any suicidal threats, hadn't made any threats specifically to anyone at that point. So law enforcement, after some protracted negotiations to try and get him out, left. Okay, because they didn't have anything. They didn't even have an emergent detention. They didn't have a crime at that point. So they ended up leaving. So later he goes to the local hotel casino, calls up some family, says, hey, you guys got to come up here. It's the only place you're going to be safe. He had rented 2 different rooms, one at a high level, one at a low level. Again, a massive law enforcement response to go up there based on his previous behavior. By the time law enforcement got up there, he had disappeared again. He was gone. Family started using the Find My Phone app, located him on Whidbey Island at that point. Okay, so trying to coordinate where he was, he ends up turning his phone off overnight, and then the next morning turns his phone back on, apparently makes a phone call to family with the similar type of behavior. They tracked it, guess what, now he's in the city of Seattle. Said he's going to a family friend's house, and made some, again, very vague comments, but with some undertones of violence there. Well, it happened to be that the house that he was going to was only a few blocks away from one of the local high schools. This was midweek, middle of the day. Okay, so again, we had a pretty decent response to that to try and track him down. We did end up locating him, and we were able to detain him without any issue. He had a couple of pistols, he had some .223 rounds magazine, and we ended up coordinating with the original jurisdiction to assist with mental health evaluation and stuff like that. Because at this point, we still had no crime, right? This was just a behavioral health crisis issue at this point. But it was enough to be concerned about it. That jurisdiction was not familiar with ERPOs, so we helped walk them through what that might look like. He ended up having a total of 11 firearms and a bunch of ammunition. The family was absolutely nothing but helpful with law enforcement and saying, please, please, please come take care of this stuff, secure it for us. We were very, very supportive of him getting the assistance that he needed, and ultimately there was no criminal charges. Throughout their investigation and the pursuit of the ERPO, they did find that there were some threats made, but they were of such a delusional magnitude that they were like, yeah, you know, like there was a threat to the son-in-law of one of the daughters, and it was to the effect of, you know, I need to kill him because he's a werewolf and he's, you know, going to do this. It's like, okay, where are we going with that? So they ultimately did not choose any charges for him. He ended up getting the assistance that he needed, stabilized, and everything is okay. You have a question?
Yeah, what did you do with the 2 firearms prior to the ERPO order being issued, and because there were no criminal charges, you would not have a PC to get in that car?
So we are able to secure firearms, right, under community caretaking based on the process that's going on at that point. If we can articulate that he's making certain statements, words, actions, and behaviors, and we're concerned for his safety and or the safety of others, we can go ahead and secure a firearm or any other weapon that might be involved. Now, it's a safekeeping issue, right? right? So it's not a permanent removal. So absent the pursuit of an extremist protection order, we would have to give that back.
Right.
Right, and that again, kind of stepping back in time, that was the issue that we faced constantly, right? Especially as our unit, because we dealt with all the mental health stuff. So you get these individuals that were suicidal, had a firearm involved with it, no crime, still eligible to possess. A week later, they get out of the hospital and they call us up and say, "I want my gun back." We had no legal footing to stand on whatsoever, right? I mean, we jumped through some hoops a little bit and make it a little, make the process a little difficult for them to get it back, but legally we could not retain their firearms. So the advent of ERPOs actually really helped with that situation so that we can step in and say, patrol has already secured this firearm, right? Patrol call 911, suicidal individual. They go out, they stabilize, de-escalate the situation, everything is great, get them up to the hospital, get them the assistance. They go ahead and secure that firearm that was sitting on the kitchen table during the incident, and they hold on to it. That comes to us, and now we go and pursue that extremist protection order, which gives us the legal standing to hold on to that gun. And then we might have to go back and get more, right? There might be more weapons, or get the CPL or what that might be.
Can I just add real quickly that if law enforcement is doing a community caretaking and securing firearms, that don't wait until the person comes to ask for their guns back, because this happened on a sheriff's department, a local sheriff's department case. They waited, I think, 6 or 9 months to go in and then petition for the ERPO. And rightfully so, the court said, well, you waited too long. This person's been out of custody, nothing's happened in those 6 to 9 months, so they denied the extremist protection order. So that's just what I thought.
Okay, really quick, give you a, well, actually, we'll skip that last example there. This was one, actually, that was very interesting. So we had 2 brothers that lived with each other, right? Elder brothers. One of them was starting to experience some diminished cognitive issues. There were some comments about suicide by cop. There was comments about it was suicide in general, but maybe I'll get the cops to do it for me. It ultimately led to us pursuing an extremist protection order on one of the brothers, not the other brother. Right? So only one of the brothers was making these comments, and we talk about access to and family access to firearms. So we did end up taking 19 handguns, 7 long guns that we secured from this residence from the one brother. Now, the other brother had another 20 long guns, 9 handguns, and they had, swear to God, tens of thousands of rounds of ammunition. These guys bought ammo by the case, okay? And it was just stacked up like Legos all through the house. Well, in Washington, ammunition is not covered under ERPOs. So we couldn't take it if we wanted to, right? We also couldn't go after the brother's firearms because they were safely secured and he had the only key to it. Okay, they lived together, however, that's that balance, and we went around a lot with that, trying to figure out what the right, appropriate response was with this, but that's what we ended up going with. Just real quick here, because I'll just throw these up. So these are the current states that have some type of red flag law, right? To the best I could research. And then these are ones that are currently under consideration. All right, there may be some more that have come through, but as of the last legislative session. So you notice some are in green and some are in blue. What do you think the difference is there? You want to take a look at it? One's in green, I'll have dates on them. The big national conversation that started right about there.
Parkland.
Yeah, that was Parkland. Okay, so prior to Parkland, these 5 states already had some sort of a red flag or ERPO law on the books. Post-Parkland, those are all the states that have added something. Okay, there's an asterisk next to New York because their law doesn't go into effect until September, but they passed their legislative session, and my understanding is it was signed and it's ready to go. It just doesn't go into effect until September. So that's where those are at. This is the current list of ones that don't have it. There's been some proposal, but it didn't get traction. There's a variety of reasons. I've had the opportunity to read a handful of these. Some of them in my opinion, as a practitioner now of this for a few years, were just not really well written. And I think that they're led to some of the breakdown of getting anything passed on it. But it doesn't mean that there's not going to be something. And I know federally they're still looking at some sort of a national application. So it was really quick, threw a lot of info at you guys.
And I know,
Yes.
since you can't stay for the whole day, not to put you on the spot in front of
No, that's
everyone,
okay.
but if people have questions for Sergeant, make sure to ask them now, and we can take a little bit longer if we need to,
Or write down my email.
or write down your,
Yeah.
So I run a safe storage program at Public Health Seattle and King County, and we were really happy to see in the new law about ERPOs that if there's an ERPO filed for a minor, that their family has to lock up their guns that are in their house or secure them in some way. Why was that specific to minors instead of for everybody? Because that just seems like generally a good practice if somebody's in a household.
I don't, in the law, it's not specific to minors, it's just that,
It's under the minor, it falls into the new language.
Yeah.
So it's.
Yeah.
That's where they inserted it
reads-
into
Yeah,
the-
reads like it's applicable just to minors, but I believe.
But it's actually applicable.
The not, and correct me if I'm wrong, my understanding of the legislative application there was that it was the circle back around to 1639.
Okay.
Right? So it's like they didn't want to, right? You want to be careful when you're writing legislation to have, competing statements. And so it was more the circle back around to, oh yeah, remember we passed safe storage?
Yep.
So you have to have that. So it was just the kind of the arrow pointing that direction.
but I think to the point of the case that you were talking about with the two brothers,
Yeah.
like if the one brother did not have his firearms locked up,
Yeah.
Well, absolutely, yeah.
Right.
Yeah, so in that situation, right, we probably still would do the same thing. Because we did everything we could to verify that this was safe storage, that he had the only access, that he had the key, that the brother couldn't get into it absent him, So it's like at some point you have to go, okay, due diligence. Yes.
So there's no repercussions if he were to let his brother have access to them? So there's no repercussion or?
Oh, yes,
Oh, there'd be
There was
repercussions for it, yeah. Yeah, legal repercussions, but that's not in our purview for this and that pursuit of the ERPO, right?
but
So
under
there's gonna be-
1639.
Right, under 1639 there would be, plus there'd be repercussions for the brother himself for gaining access and possessing them, right? I mean, so there'd be some stuff, yeah.
The ERPOs that were conducted in the 14-day hearing or permanent hearing, were any of those CPLs surrendered prior to that hearing?
No, they hadn't, and only because the ones that have, so generally when we get that initial ex parte that we're petitioning for, it's something that happened right now. So unless that CPL was obtained at the time of incident, it's unlikely that we have it. And if we go do the service on it, now in those, there was no CPL in any of those three that happened to be denied. But we theoretically should be obtaining that upon service of the ex parte order. We have had some issues where people have failed to turn that over to us, and we've had to go back and kind of leverage that and say, okay, we can go get a warrant if you don't turn this over, and they have been turned over.
And then do you have a process then to return, or do you send that person back to the law enforcement agency that issued the CPL? If they,
For the CPLs or for the firearm?
for the CPL,
Yeah, so that,
if they no longer for the review hearing, they come back and the order is denied,
right.
do you issue them their CPL
No.
back? Or is that-
No, and so as goofy as it sounds, it's actually easier to get your gun back than it is to get your CPL back. It is. I mean, just the bureaucracy and the red tape that goes through it, because they have to go through a whole process of reissuance of a CPL, right? They got to go back to the county of issuance. They got to go back through the application process, the approval process, because that's DOL that's pulling that on the back end, right? It's actually easier if that doesn't get passed, because now they're just, essentially they came back to Seattle PD and went through the evidence unit and just said, I want my gun back, right? And we have, the evidence unit does their process and releases it. They actually can get that firearm back faster than they can get their CPL reissued. Yeah.
For Ken, I'm currently updating the Stonehenge County model policy, trying to make sure that I've got all legislative changes. Do you have a summary of those?
We do, and I have a notebook that I made just because I brought it in case anybody asked. So I have all of them in a notebook, and then I know Renee and folks have all the details, but I speak on the ones that apply to our jobs, we certainly do. And I'm happy to share that.
Yes.
Yes,
Can I,
Renee, favorite student.
Yeah, I know, sorry. Eric, can you just, before you leave, give a quick recap of at least one of the cases that you've worked really closely with a family? And I know you've had some where they've actually come back and thanked you, some of the people who had their firearms removed. This can be,
Yeah, no, and that was actually one of the examples I was skipping through for time, but we did have one that really stood out, and it was a case of an individual, wife, adult son, and all at home together, and this guy was experiencing a lot of depression, some substance abuse, and ultimately got to the point where he attempted suicide, and he was almost successful in that. So wife and son were home, he was in the back bedroom, and they hear what they think is a gunshot go off. They go back in and look, and sure enough, he had actually shot himself in the chest with a firearm. And he was laying on the bed, 911 was called, massive fire and police response, they show up. They end up securing the scene very, very quickly, scoop and run this guy to the hospital. He just shot himself in the chest. Scoop and run him to the hospital. He survived the gunshot. And we obviously pursued an ERPO on him and served him while he was in the hospital. With the support of his family, of his wife and his son, that individual, he was nothing but thankful over the process. And he truly stated that this process saved his life because he likely would have attempted it again. And this was quite a life-changing experience for him, and was very, very supportive of the process, to the point where he actually agreed to go on tape with us, and we recorded him giving his video account of kind of what got him to that process. And it's incredibly powerful and moving. We did agree with him that he did not want that released for the public. We did it to put together as a training for law enforcement, which we will be capturing now. We're putting the finishing touches on the whole presentation. And it is just going to be for law enforcement, so I'm sorry it's not going to be released to the public. But it is an incredibly moving tale of what this individual went through. And it culminated with the fact that his father had committed suicide at the same age that he was now. And it's a really moving story. And he's an incredible individual and a very good advocate in his family of this whole process and having ERPOs in place. And we've gotten, in addition to that, we've had multiple families at those hearings come in and thank us publicly because they truly feel that we saved their loved one's life by going through this process. So there's a lot of that out there. There's been very little, if any, pushback from family members. And actually, I know I'm killing time here for it. But one more caveat, and Kim mentioned it early on, is that there's been very, very few families that have petitioned for these. Okay. Our belief in all of the ones that we've done and talking with the family members is that that's probably not going to change. Okay. And the reason behind that, my professional and personal opinion on it is, if you have an individual that's experiencing some sort of behavioral health issues that are either mental health related or just manifesting in threatening behavior, they're engaging in dangerous stuff, and they have a firearm or they're indicating that they want to obtain a firearm, that family dynamic is probably pretty tenuous, right? And so you have these families that are walking on eggshells and just worried about the behavior of the individual and just trying to stabilize and get through every single day. And so to have one of those family members go to the court, put their name on the documents, and petition to remove those firearms from that individual, good luck, right? That's why my professional belief is we're not going to see a big jump in those families petitioning for them. We advocate that that's okay. Because the most important part of this process is for that individual that's experiencing these issues to get stabilized and to get back to a better place in their life where we're not worried about this behavior, right? That's the whole purpose of this, is to try and interdict during that moment of behavioral crisis, during those moments of concern for themselves or others, go ahead and secure that firearm, take it out of the equation for the time being, and then let them stabilize and get back in a good place in their life. And then they can move back on with all of their day-to-day activities and their family. The most important part of that is having that strong family structure so that they can help heal and get back to a good place. So we have no problem kind of being the heavies and going in and filing that paperwork and say, we'll go ahead and take this burden for you because you need to be there for your loved one to help them recover and get back into a good spot. So that's just my little 2-cent soapbox on that. Anything else?
Thank you.
Thank you.